is to stand up and talk for my rights. I know what that is. See? And I don't care who the guy is. Because my right is my right.
Welcome to Ask the Lawyer with Brian Figueroa of the law firm of Figueroa and Associates for a free, no obligation legal consultation on issues such as immigration, personal injury, bankruptcy, divorce, family law, estate planning, wills and probate, deed transfers, civil rights, criminal defense, workers' compensation, and taxes, both individual and business. Call us at 855-768-8845. That's 855-768-8845. Or visit us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer. You have questions, we got the answers.
Hello, my name is Deandra Archibald, and I'm an attorney. I practice workers' compensation law, and I have some information for you today. If you work in some type of employment that requires you to do something repetitively, you may have a workers' compensation claim. Typically, we tell employees to file this claim when they're close to retirement. The claims include hearing loss claims if you work in a noisy environment, such as working with New York City Transit Authority, if you work on the trains, if you work in a construction site and you've been a laborer for a very long time, if you work in play setting or, in movie operations and you've had to do repetitive lifting, even as a typist, you're typing repetitively. All of these things can cause injuries over time. With hearing loss, a hearing loss claim, even if your employer provided you with hearing protection and gave you regular hearing tests on the job. Some employers give you a hearing test every year, every 2 years. Even if that was the case and they never told you had hearing loss, once you've retired, if you've noticed that you've had hearing loss once you're removed from the job, the waiting period is 90 days. By the way, you have to be removed from the noisy environment for 90 days for your hearing to level out. You can go and get tested. If you do have some sort of hearing loss, you can be compensated for that under workers' compensation law. If you work in a sedentary setting where you type all day for 8 hours a day, 5 days a week, and you develop carpal tunnel syndrome, or what they call tennis elbow, that also can be compensated. So if you lost any range of motion or you've developed some type of injury to that body part because of this repetitive stress, then you can also be compensated. You will receive a settlement check by filing for workers' compensation. So if you believe that you've worked in a job for a period of time and you do repetitive activities in that job and it may have caused you pain, if you work in a job where you need to walk a lot. Say you work in transit and you have to walk on uneven surfaces on the tracks, or in a delivery service type of setting where you're constantly on your feet going from door to door, or in a construction setting where you are also walking on uneven surfaces or climbing up ladders or crouching. You may develop plantar fasciitis. You may develop issues with your knees, other issues with your feet. You may develop back pain. You never know. All of these things are called occupational disease claims, okay? They're called repetitive stress injuries also because they can happen over time and they are also compensable. You can get your medical treatment paid for the rest of your life for these injuries, and you may also be eligible for a settlement check. So if you think that your job may have caused some long-term issues due to your day-to-day activities, give us a call. We can walk you through it and find out if this is a compensable claim. The telephone number to call is 855-768-8845. That's 855-768-8845. Give us a call today.
When should you seek a workers' compensation attorney in New York? Most people seek an attorney when their claims are denied or they're receiving improper treatment for their injury. There are other reasons why you should speak to an attorney today, and I'll name a few. You should seek a workers' compensation attorney when your injury happened at work, but a third-party vendor, rather than your employer, is responsible. You should also speak to an attorney if a defective product caused your injury, making you potentially eligible to file a claim for product liability against its manufacturer. You should also speak to an attorney if you're the victim of toxic exposure, such as asbestos. You should also speak to an attorney if your employer knowingly violated the law and required employees to work in unsafe conditions. And you should speak to an attorney if you work for a very small employer who doesn't carry workers' compensation insurance. For a free case evaluation, call 855-768-8845. That's 855-768-8845. Remember, the lawyer you hire does make the difference.
Ooh, my honey, you got me working day and night.